Hello, my dear students. We are studying Industrial Disputes Act 1947, and under this act, we are talking about the powers of the appropriate government. Under that head, today we'll talk about the power to remove difficulties, powers of the appropriate government to remove the difficulties or doubts, and under Section 36A, and we'll also talk about the power to exempt given to the appropriate government under Section 36B, and power to make rules under Section 38 of the Industrial Disputes Act 1947. This is video lecture number 28. So we start with Section 36A, power to remove difficulties. If in the opinion under Section 36A, the provision is given that if in the opinion of the appropriate government, any difficulty or doubt arises as to the interpretation of any provision of an award or settlement, it may refer the question to such labor court, tribunal, or national tribunal as it may think fit. So this is the power given to the appropriate government under this Section 36A, that if the appropriate government is of the opinion that there is any difficulty or doubt arises for the interpretation of any provision of an award or settlement, then this question or this matter may be referred to the labor court, tribunal, or the national tribunal as appropriate government may think fit. And the labor court, the other provision is that the labor court, tribunal, or the national tribunal to which such question is referred shall, after giving the parties the an opportunity of being heard, decide such question, and decision shall be final and binding on all such parties. So if there is any labor court or the tribunal or the national tribunal to which such question is referred shall, after giving the parties an opportunity of being heard. So whether it is labor court, tribunal, or the national tribunal, they will provide the opportunities to the parties and decide such question, and it's the decision of these bodies, the labor court or the national tribunal or the industrial tribunal, shall be the final and the binding on all such parties. So these are the powers given to the appropriate government under Section 36A. We call those powers power to remove difficulties. And under Section 36B, there is a power to exempt and power given to the appropriate government, and where the appropriate government is, under this 36B, a workman who is a party to a dispute shall be entitled to be represented, I beg your pardon, in any proceeding under this act by any member of the executive or office bearer of a registered trade union of which he is a member, any member of the executive or other office bearer of a federation of a trade union to which the trade union referred to in clause A is affiliated, and where the worker is not a member of any trade union, by any member of the executive or the office bearer of any trade union connected with, or by any other workman employed in the industry in which the worker is employed and authorized in such manner as may be prescribed. And an employer who is a party to a dispute shall be entitled to be represented in any proceeding under this act by an officer of an association of the employers of which he is a member, and an officer of a federation of the association of employers to which the association referred to in clause A is affiliated, and where the employee is not a member of any association of the employer, by an officer of any association of employers connected with or by any other employer engaged in the industry in which the employer is engaged and authorized in such manner as may be prescribed. And no party to a dispute shall be entitled to be represented by a legal practitioner in any conciliation proceedings under this act or in any proceeding before a court. And in any proceeding before labor court, tribunal or the national tribunal, a party to a dispute may be represented by a legal practitioner with the consent of the other parties to the proceedings and with the leave of the labor court, tribunal or the national tribunal, as the case may be. So, my dear students, under section 36B, where the appropriate government is satisfied in relation to any industrial establishment or undertaking or any class of industrial establishments or undertaking carried on by a department of that government, that adequate provisions exist for the investigation and settlement of industrial disputes in respect of workmen employed in such establishment or undertaking or class of establishments or undertakings. It may by notification in the official gazette exempt conditionally or unconditionally such establishment or undertaking or class of establishments or undertakings from all of any of the provisions of this act. So under section 36B, this power is given to the appropriate government, can exempt through a notification in the official gazette, conditionally or unconditionally, such establishments or undertaking or class of establishment or undertakings from all or any of the provisions of this act. So this is again the one more provision given to the appropriate government and power given to the appropriate government under section 36B. And there are certain powers given to make rules under section 38 to the appropriate government, and the appropriate government may under section 38 subsection 1, the appropriate government may, subject to the condition of previous publication, makes rules for the purpose of giving effect to the provisions of this act. And the other one is, in particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters. So without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters. These matters are A, clause A, the powers and procedure of conciliation officers, boards, courts, labor courts, tribunals and national tribunals, including rules as to summoning of the witness. This power is also given. The production of the documents relevant to the subject matter of an inquiry or investigation, the number of members necessary to form a quorum, and the manner of submission of our reports and awards. So the power and procedures of conciliation officers or boards or courts or labor courts or tribunals or national tribunals. Then in AA, the form of arbitration agreement, the manner in which it may be signed by the parties, the manner in which a notification may be issued under subsection 3A of section 10A, the powers of the arbitrator named in the arbitration agreement, and the procedure to be followed by him. Then in clause triple A, the appointment of assessors in proceedings under this act, the constitution of grievance settlement authorities referred to in section 38, the manner in which industrial disputes may be referred to such authorities for settlement of the procedure to be followed by such authorities in the proceedings in relation to disputes refer to them, and the period within which such proceedings shall be completed. Then in clause B, the constitution and functions and the filing of vacancies in works committees and the procedure to be followed by such committees in the discharge of their duties. And in clause 3, the allowances admissible to the members of the courts and boards and presiding officers of labor courts and tribunals, national tribunals, and to assessors and witnesses. In clause D, the ministerial establishment which may be allotted to a court, board, labor court, tribunal, national tribunal, and the salaries and allowances payable to member of such establishments. And another power is under clause E, the manner in which and the persons by and to whom notice of strike or lockout may be given, and the manner in which such notice shall be communicated. So the appropriate government is empowered or having the power to make rules for these matters also. And under clause F, the conditions subject to which parties may be represented by legal practitioners in the proceedings under this act before a court, labor court, tribunal, or the national tribunal. And under clause G, any other matter which is to be or may be prescribed. So all these powers are giving to make rules given to the appropriate government, and then the rules made under this section may be, provide that a contravention thereof shall be punishable with fine not exceeding rupees 50. So these are the powers to make rules given to the appropriate government. And all rules made under this section shall, as soon as possible after they are made, be laid before the state legislature, where the appropriate government is the central government, before both houses of the parliament. And every rule made by the central government under this section shall be laid as soon as maybe after it is made before each house of the parliament, if this session is at least for 30 days there. So thank you so much, my dear students, and I hope now you have understood that what are the powers given to the appropriate government under the section 36B, 38, and 36A. And in our previous lecture, we have gone through the powers given to the appropriate government under the Act under section 9B and section 10, where the appropriate government can refer the matter or the dispute for the labor court, tribunal, or the national tribunal for reference. So this is for today's lecture. I hope this lecture will help you, my dear students. And in our next lecture, we'll go for a new topic under Industrial Dispute Act 1947. So this is all for today's lecture. Thank you so much. Have a nice day. Have a good time. Thank you.